This is a lecture for professional responsibility for my professional responsibility course. And this is our part 2 of Model Rule 3.8. 3.8 is about special duties of prosecutors, special ethical restrictions on prosecutors. This is a very long rule with sections A through H. I did A through D in one video. And we're going to pick up with E in this video to avoid making the videos too long. 3.8e says that a prosecutor shall not subpoena a lawyer in a grand jury or other criminal proceeding to present evidence about a past or present client unless the prosecutor reasonably believes, 1, the information sought is not protected from disclosure by any applicable privilege, 2, the evidence sought is essential to the successful completion of an ongoing investigation or prosecution, and 3, there is no other feasible alternative to obtain the information. If you haven't had criminal procedure yet and you're watching this video, I should just explain by way of background that grand jury proceedings, we have very relaxed. We basically don't have exclusionary rules. And also the defense lawyer is not in the room getting to object to things or present their side of the story. And so we have a concern that prosecutors will subpoena a criminal defense lawyer and kind of go on a fishing expedition. And this rule is supposed to discourage you from doing that. And so you're not allowed to ask for information protected by attorney-client privilege, even though it may be unclear whether it would be inadmissible in a grand jury in your jurisdiction. It's necessary information, and there's really no other way of getting it. And sometimes that will be true, and sometimes the lawyer will have to testify. The comment for paragraph E says it's intended to limit the issuance of lawyer subpoenas in grand jury and other criminal proceedings to those situations where there is a genuine need to intrude into the lawyer-client relationship. Okay, F. What a terrible slide. Look at how cluttered that is. And you know what? I'm sorry for this, except that this is all one sentence, and I really couldn't figure out how to break it up. Okay, so F says, except for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose, refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused, and exercise reasonable care to prevent investigators, law enforcement personnel, employees, and other persons assisting or associated with the prosecutor in a criminal investigation from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6 or this rule. Now, I mentioned when I did a lecture on Rule 3.6, that's about talking to the media, that applies to prosecutors, as does 3.8, which is an even higher standard. So 3.8F is our sort of parallel to 3.6 and adds on another layer of ethical responsibility for a prosecutor. And so you weren't supposed to make under 3.6, you can't make extrajudicial statements that could are likely to prejudice the proceedings, right? To kind of influence what the jurors or the judge is going to think or feel about the case. But Rule 3.8F says you're not even allowed to do things that just heighten the public condemnation of the accused. And so be careful about this. I've mentioned other high-profile cases from the last few years where I've seen for notorious crimes where prosecutors have held press conferences and really kind of demonized the defendant. And even though I think the defendant may have deserved to face criminal charges and prosecution and be punished for their crime, I have seen prosecutors violate this ethical duty by going on TV and kind of going on a Jeremiad about how evil the person they just arrested is. And so you can't do that. Now, please note, you as a prosecutor do not have complete control over or liability for what your local police chief or the arresting officers or other investigators or your mayor or governor or other people may say to the media. And so you're supposed to make some reasonable efforts to discourage them from talking to the media and making statements that will heighten condemnation of the accused or influence the proceedings, but ultimately they don't work for you as a prosecutor. So it won't be an ethical violation for you if the police hold a press conference and go on and on about how evil and demonic the person that they just arrested is. And so now, whether they're allowed to do that is another body of law besides legal ethics. But in terms of the prosecutor, you're certainly not allowed to encourage the police to do things, make statements to the media that you wouldn't be allowed to make. So don't have the police kind of do your dirty work of stirring the pot. Comment 5 says that paragraph F supplements Rule 3.6, which prohibits extrajudicial statements that have a substantial likelihood of prejudicing an adjudicatory proceeding. Now, please note that the very fact that you're announced that somebody's being indicted, right? You can say that they've been indicted. That's a procedural step. Obviously, people are going to think less of someone who's been indicted for crimes, or in a politician who's been impeached, maybe, but not convicted. But you should avoid comments that really don't have any extra comments beyond that, that have no law enforcement purpose except to increase public condemnation or opprobrium of the accused, right? That now you're trying to create stigma. Okay, next rule. And G and H are very similar, and I want you to associate these with, these are like, I call these our Innocence Project rules. G, when a prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall, 1, promptly disclose that evidence to an appropriate court or authority, and 2, if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless a court authorizes delay, and undertake further investigation or make reasonable efforts to cause an investigation to determine whether the defendant was convicted of an offense that the defendant did not commit. So I want to go back for a second and have you notice G, and keep an eye on the details that distinguish G from H, but also 1 from 2. So 1 is talking about, you realize you come into evidence that someone who's sitting in jail who was convicted in outside, not by your office or jurisdiction, was probably wrongfully convicted, that somebody else did it. And how does this happen? Well, let's be honest. You bring somebody in and you arrest someone, and now and they confess to committing some other crimes, right? While you have them in custody, when they're and they confess to other crimes that somebody else is already sitting in jail for. And this could be another jurisdiction, like you're in Houston and they committed a crime that somebody else was charged with and convicted up in Dallas, another part of the state several hours away, or it could be another state altogether, right over in Louisiana. And so so this is what happens: is you arrest somebody and they agree to talk and agree to confess, and then they confess to a bunch of crimes, some of which somebody else convicted other people for. And that triggers 3.8G1, where what do you have to do? Notice you have to disclose it to a court in that jurisdiction. By the way, somebody over here where I am in my office just gave us some new, credible, and material evidence that maybe somebody that is sitting in jail in your jurisdiction didn't do what they're serving time for. Now, what if it was in your office? Even if it wasn't you as the prosecutor who brought the case, if another attorney in your prosecutor in your jurisdiction did, then you have to disclose it to the defendant or their attorney. And sometimes they don't have an attorney anymore if they're sitting in jail, right? They had court-appointed counsel for their trial, and then the representation ended when they went to jail, went to prison. And you actually have an affirmative duty to investigate further and figure out whether there's additional evidence that this was a wrongful conviction. And so and you have to do this even if you don't have enough to prove it yet, but you have some new credible material evidence under G, then you now have a duty to look for more evidence. Here's H. By the way, we're at the end, we're getting near the end of 3.8. When you know of clear and convincing evidence, so that's stronger than credible and material. So it's clear and convincing evidence. In other words, all the evidence you need. Establishing that the defendant was in the prosecutor's jurisdiction, was convicted of an offense that the defendant did not commit, the prosecutor shall seek to remedy the conviction. Now, just a second here. I got to tell you something. We don't talk about my morality and my opinions and being all judgmental of what other people are doing a lot in this course. We focus on the model rules. But if you're a prosecutor and you know there's somebody sitting in jail who there's overwhelming, clear and convincing evidence that someone else committed the crime, I think you have a there's something wrong with you that you would leave an innocent person in jail, right? So what is wrong with you? So of course prosecutors should do this. And what's disturbing to me is that we had to make a rule. I can't believe we have to make a rule about this because people are so awful, right? So, all right, enough about that. Once in a while, I get a little bit preachy. And yes, for those of you who are prosecutors out there who like leaving innocent people in jail, I am judging you. And so now, back to this, you have an ethical duty to seek to remedy the conviction. I want to say something else for my students. This is kind of sad. Very, very, very rare that we see prosecutors disciplined by state bars. It does happen. We had a high-profile case here in Texas a few years ago where a prosecutor had all kinds of misconduct, lots of wrongful convictions, and they knew about it and stuff like that, withholding evidence and fabricating evidence and stuff like that. That prosecutor is actually sitting in jail now. And so that this does happen, and it's not hard to find a case state to state of the bad apple prosecutor who has been disciplined and maybe even is charged themselves with crimes. But the fact is, most of the time, prosecutors get away with it, right? That we don't have a lot of grievances, and for whatever reason, the state bar doesn't really state bars don't have a history of going after prosecutors. And you can read the disciplinary actions. I follow the disciplinary actions in my state, and you can go month to month to month to month, and it's extraordinarily rare that I see a prosecutor being disciplined for something. And maybe that's because they're all just squeaky clean honest, but I'm skeptical. So, okay, let's go to comment 8. Once the prosecutor knows of clear and convincing evidence that the defendant was convicted of an offense that the defendant did not commit, the prosecutor must seek to remedy the conviction. Necessary steps may include the disclosure of the evidence to the defendant, requesting a court appoint counsel for an unrepresented indigent defendant, which is often going to be the case if they're sitting in a jail cell. And where appropriate, notifying the court that the prosecutor has knowledge that the defendant did not commit the offense of which the defendant was convicted. By the way, I want to say this is a film recommendation or movie recommendation for my students. There's a pretty recent movie that has come out called Just Mercy, made by a professor named defender Brian Stevenson. And I really, really recommend to my students that you watch that film. It's a true story. It's very moving and it's well done. And part of the plot, I hate to spoil it for you, is that you have a prosecutor who is repeatedly presented with evidence that of a wrongful conviction and doesn't do anything about it for a long time. And so, and this rule is partly in light of these types of situations. Wrongful convictions are very, very upsetting, right? And it's very tragic. Okay, and these rules, G and H, were actually added pretty recently in legal ethics history terms, right? 2008 is I know for some of you, you were, that's your fond childhood memory days, but in legal ethics, that's yesterday. So these are newer rules, and they may not have been adopted yet by your jurisdiction, and the people you're working for after law school may have graduated before these rules were adopted by the ABA. So they were added in 2008, and they create post-conviction duties for prosecutors to disclose new, credible, and material evidence they come to know of that creates a reasonable likelihood of a defendant seeking that the defendant did not commit an offense, that's G, and actually they have a duty to seek to remedy the conviction when they have clear and convincing evidence of a wrongful conviction in their own jurisdiction. We also have a pretty recent ABA ethics opinion from 2019 that's obligations of prosecutors when negotiating plea bargains for misdemeanor offenses. Instead of making a whole separate video about this, I'm just going to hit 4 bullet points about this. And basically what they said, and why am I covering this? The MPRE examiners sometimes include questions that are based on recent ethics opinions, and this would count, treating the opinions basically as if they were the rule, any like clear-cut lines drawn in the ethics opinion. So prosecutors, when they're making plea bargains with people in misdemeanor cases, that's what we're talking about here. We're talking about serious felonies. We're talking about misdemeanors and plea bargains for misdemeanors. 1, ensure that each charge incident to a plea has an adequate foundation in fact and law. So you don't get to, we're not going to let you pile on kind of flimsy, bogus extra charges just because the stakes are lower because it's a misdemeanor. 2, ensure that the accused is informed of the right to counsel and the procedure for securing counsel. 3, avoid plea negotiations that jeopardize the accused's ability to secure counsel. So in other words, you should never say, we'll offer you a deal, but no deal if you get a lawyer. I know they do that on the cop shows, and you're not supposed to do that. And last, irrespective of whether an unrepresented accused has invoked the right to counsel, to avoid offering pleas on terms that knowingly misrepresent the consequence of acceptance or otherwise pressure or improperly induce acceptance on the part of the accused. And so we're worried about high pressure, pounding the table, plea offers like you better take this, or there's no reason not to, and so on. And as you may know from your other courses, we have cases where they have gone to the Supreme Court where prosecutors offered a plea bargain to a criminal defendant and accepted them, and neither the prosecutor and then sometimes the defense attorney didn't explain to them that this would have immigration consequences. So you have someone who's an immigrant and they could be undocumented or they could be legal here and have a green card, and the conviction could have consequences for their immigration proceedings or result in them being deported. A conviction, even of a misdemeanor, can have implications for child custody later on. If you're seeking custody or visitation rights of your children, if it's a sex charge, it could, even pleading to a misdemeanor charge may, in some jurisdictions, result in being added to the sex offender registry, which can create all sorts of stigma and disqualify you for certain types of employment. When you are applying for law school and when you do your application for bar admission, you have to disclose misdemeanor convictions, of course. And so, and for a lot of times the accused sitting there, they're just worried about more serious charges and avoiding jail, and they're not really thinking about all of the kind of serious consequences of having a misdemeanor conviction on your record. And as a prosecutor, you definitely shouldn't misrepresent that or mislead the accused. Okay, really quickly, actually, I'm going to save 3.9 for another video. So I think we've gone on long enough. We're going to stop here, and this ends our conclusion of Model Rule 3.8.